Plaintiff is the wrongdoer is based on the legal maxim ex turpi causa non oritur actio, which translates to no action arises from an immoral cause. That is, a person should not be able to benefit from their own wrong actions. For example, if the defendant has a factory that is shut down and locked, there are proper signboards clearly indicating that entry is prohibited and that the premises are dangerous. And the plaintiff ignores the signboards, jumps over the gate, goes into the factory and gets injured, and then sues the defendant for the injury. Here the plaintiff is clearly the wrongdoer, and the defendant has done everything that is legally and practically necessary to stop the trespassing and to make people aware of the danger in the factory. So the defendant is not liable. This defense will apply in two situations. If the plaintiff caused the defendant to commit the wrongful act, which the defendant would not have committed otherwise, or the plaintiff alone is responsible for the loss or the damage, and it was not the defendant's duty to prevent the loss, or the defendant took all reasonable steps to generally prevent such an incident. Like the plaintiff in this example has taken all the steps to prevent the trespassing and to make people aware of the danger. If we look at voluntary non-fit injuria, contributory negligence and plaintiff is the wrongdoer, you can see that there is a natural progression. Here the plaintiff knew the risks and provided consent. Here the plaintiff has contributed to the wrong, and here the plaintiff is fully responsible for the wrong. This principle of plaintiff is the wrongdoer was originally enunciated by Lord Mansfield in the case of Holman versus Johnson in 1775.